504 has a myriad of definitions, or it covers a myriad of things. When you look at Section 504 of the Americans with Disabilities Act, what it's designed to do in the Americans with Disabilities Act generally is to protect against discrimination in public places for folks with disabilities. This transcends employment, looking at education, looking at transportation, looking at health care. So Section 504 of the Americans with Disabilities Act, just on me giving you that alone, can easily fit within the Department of Education, the Department of Health and Human Services, the Department of Transportation, right? But when we look at what's happening with parents and in education, I'm a former school teacher, family of 5 generations of educators. I'm in generation 4. Individual education plans for students with disabilities are commonly referred to in our public and private school systems as quote unquote 504s. So what this is education or special accommodations for students with special needs. And there is a belief when looking at the prayer for relief in this suit that's been brought about by the attorney generals for 5 states, that Section 504 in the American with Disabilities Act is something that's on the chopping block, and they're having or wanting to have the courts declare this unconstitutional. In reality, the Georgia Attorney General has correctly stated that that's not what this is about. I can understand, as a lawyer, the confusion behind this. The confusion is when you hear 504, parents are thinking of the education plans for their students and how this impacts education. But this lawsuit isn't about this. This lawsuit is really about how are we defining disabilities pursuant to Section 504, and whether or not, what is this? Gender dysphoria, based on a rule that Department of Health and Human Services set forth last year, can be defined as a disability. That's what the lawsuit is actually about. Actually having the conversation about 504 as part of a prayer for relief is really to give the courts an opportunity to add clarity and context in anticipation that this case is going to go all the way to the United States Supreme Court in light of the elemental confusion that's going on. You know, President Trump, with the number of executive orders and sweeping reforms, it seems as though we have parties on one side or the other trying to have broad sweeping reforms, and we're confusing lawmaking, which is the function of the legislative branch, with rulemaking, which is the function of the executive branch. Rulemaking is to ensure policies and practices are consistent with the laws that pass, right? And the courts are to interpret when there is a tension between the two. So now when you have, pursuant to 42 U.S. Code, Section 12211B1, telling you that transvestism and transsexualism and gender identity are specifically excluded as disabilities pursuant to, resulting from physical impairments are not protected disabilities. When you look at gender dysphoria, they're more closely aligned with those things than they are with disabilities that are covered historically under the Act. So it seems like President Biden's Department of Health and Human Services, under the leadership of Secretary Javier Becerra, was seeking to expand disabilities to include something that was explicitly, essentially excluded by association with those terms under the Americans with Disabilities Act. And that is what is responsible for this lawsuit.
Okay. So I'm going to go into these questions now.
Sure.
So I have, if a judge were to grant their demands for relief,
yes,
what would this look like? Just gender dysphoria or 504 as a whole?
I am likely to tell you 504 as a whole being abolished or determined unconstitutional is not what this is going to look like, because the intent behind the party, or behind the lawsuit, and it's been stated by our governor, our governor, our Attorney General Arkansas, other attorneys generals that are parties to this suit, they're not interested in wiping out Section 504. What the true interest is if you were to include, and we're looking at states that have conservative leadership in some, liberal to moderate and progressive leadership in others, if you have the ability, because states are not willing to include gender dysphoria as a disability, they are subject to lose federal funding. What these conservative AGs are saying is that could create a problem with funding in education, because if you're pulling federal funding by saying that a state is not complying with federal law, which is, you're able to do that, that then creates problems for 504 pursuant to education and students and education funding. So what this lawsuit is really about is stopping the inclusion of gender dysphoria as a disability, because it's inconsistent with the read that has been given by the U.S. Congress pursuant to 42 U.S. Code, Section 12211B1. That's what this is really about. So what would this look like? The court essentially saying gender dysphoria is not a disability as defined by the Americans with Disabilities Act, is what the outcome would really be here, if the relief that is granted is truly given. But right now, we're in a stay, right? And the reason that we're in a stay with this case is to give the Trump administration, with our new Secretary of Department of Health and Human Services and his team, an opportunity to look at this rule. So the Biden administration went through the steps of putting this rule in place. We've now had a change of leadership, different political party, different thoughts about things that are gender affirming. And the question becomes, is there going to be a modification to this rule? And by the court staying this, what that looks like is saying we're not going to decide this case on the merits until we have heard from the Trump administration and to see whether or not this rule is going to be put into force and effect. That determination is an executive function. So essentially, when we're looking at the executive orders and what our president and our executive branch actually has the ability to do, it actually does have the ability to stop the implementation of this rule by putting something in place that's superimposed and takes its place. So the court is saying until the Trump administration and our new Secretary of Health and Human Services and his department has taken a look and re-examined this issue, they're not going to decide the outcome of this case, because it may become very well null and void.
Okay, so
yeah.
Off these questions, it sounds like one administration, meaning the Biden administration,
Yes.
might have went about it the right way, and the current administration isn't necessarily going about it the right way. Is that
right now?
Is that an accurate way of? Is that accurate to say?
I would venture to tell you, both administrations. Let's go here. Both administrations have gone about this their way. There is a possibility here, and what we're saying is the Biden administration essentially sought to probably expand disability to include something in the sphere or space of the LGBTQIA plus and gender affirming community. It was favorable, right? So when you want gender dysphoria to be defined as a disability, what it is essentially doing is opening the door for transvestism, transsexualism, and gender identity disorders, essentially. It opens the door for an interpretation that they should be considered disabilities too. So that's what there's a perception that the Biden administration, with the implementation of this rule, sought to do. It's not the role of executive function. You set policies and procedures in place to support the law that is created by Congress. Similarly, if I were to draw a parallel for you, when we look at the Civil Rights Act of 64, it was to prevent discrimination on the basis of race and a few other categories. What it did not include was sex. In order to amend the Civil Rights Act of 64 to include sex as a protected class, or gender essentially as a protected class, in order to do that, there had to be an amendment passed by the United States Congress to get that included. Similarly, if you want to get gender dysphoria, transvestism, transsexualism, and gender identity disorders included as disabilities under the Americans with Disabilities Act, likewise, you need to go back to Congress and have an amendment approved and put in place so it's codified as federal law. That is not something that can be changed by one or from administration to administration through rulemaking, because rulemaking is supposed to support and create policies that are consistent with federal law. So you don't have the ability as an executive branch to expand the law. The courts come into play, and this gets to court when you have a situation similar to this. There are states that are conservative in nature. If you look at the parties, or the states that are party to this lawsuit, these are states that have conservative attorney generals, conservative governors, Republican governors, generally Republican legislators or legislatures telling you, you're not going to include gender dysphoria as a disability, such that if we refuse to accept and see and treat gender dysphoria as a disability, that you can affect my funding in education, because 504 is broad enough, recall, to cover a number of things. It transcends agencies. You're looking at transportation, you're looking at education and public accommodations, and you're looking at health and human services. So you can cut my funding in one area if I don't do something in this particular area, and I'm telling you that this is not a disability as currently, defined by the Americans with Disabilities Act. So that's what this lawsuit really comes down to. And if it is possible, when you look at what the courts want to do, and there is an expectation that because there are heightened feelings on both sides of the issue, that this thing is going to get appealed all the way to the United States Supreme Court. You put something broadly here in your prayer for relief to talk about Section 504. If that rule, what these states are saying, is if the rule that causes disability to be defined to include gender dysphoria is actually implemented, that does make the implementation of Section 504, that does deem it unconstitutional. And this is a law that has existed for 52 years now with express language from Congress, pursuant to 42 U.S. Code 12211B1. These types of issues are not covered by the statute. So now, if you include this with this rule, you're essentially trying to amend federal law without going through the correct legislative process to do it. And that is why that language is actually in the complaint. So it's more strategic than anything. It is not geared towards ensuring students don't get their individual education plans. And I can understand the confusion, especially given the conversations that are taking place in parallel about the abolition of the Department of Education. So that is what's causing a frenzy. Colloquially, when we hear 504, we hear you're messing with my kids' individual education plan and their accommodations in their education. And that's something that no one is going to go for. So there's a fear factor that really is unfounded based on confusion with how we colloquially talk about 504. There's Section 504 of the Americans with Disabilities Act and their individual education plans, and dealing with education all the way through, our institutions of higher education, where you need a special accommodation and it's medically determined and you receive that. So there's an elemental confusion, and it's being conflated now when it truly is not the same thing.
Okay. let me switch up my camera angle, get a tighter shot,
Okay.
maybe a little wider, and I can bring my camera on over this way.
Okay.
So hold that knot, and I'll get this in there. Just a little bit more. Voila. Okay. So that looks good.
Okay.
All right. So outside of these questions, those something that we were talking about before we even started rolling on camera.
Sure.
I remember you even went to the extent of saying, "Hey, let's look up gender dysphoria," if I'm saying it right.
Sure.
And we did that. So
We did.
For what reason would the Biden administration even? What would you say? Possibly, what would be one of those reasons that the Biden administration would say, "Hey, let's make this a thing of 504 and try to include this as disabilities."
So let's talk about what gender dysphoria actually is.
Right.
What gender dysphoria really is a feeling of distress that could potentially occur when a person's gender identity does not actually match the sex that they are assigned at birth. We look at these pronouns, he, his, him, she, her, hers, and we're using gender affirming pronouns in healthcare, issues with sexual orientation, abroad, across society right now, issues affecting the LGBTQIA plus community, hate and hate crimes associated with this, and the physiological implications and what comes about as a result of gender dysphoria oftentimes leads to certain issues that can be classified as mental illness, right? And when you talk about this, that we can understand why folks would see that or want that to be included as a disability pursuant to 504 of the ADA. But here's the deal. When the American with Disabilities Act was approved or was passed 52 years ago, it was with the explicit exclusion of related issues such as transvestism, transsexualism, and gender identity disorder. Gender dysphoria is closely linked to or related to this, right? It's more closely related to what has been specifically excluded that would cause you to say it is a read antithetical to what the statute actually does cover as a disability. But let's look at this. When you look at the law in our United States Constitution, the number of times it's actually been amended, it is a living, breathing document. And when you're looking at the black letter law or the letter of the law versus the spirit of the law of the law actually drives things oftentimes on what causes us, or the spirit of what the law should be, based on societal norms and societal needs, drives change in this country and the need for legislation. Black folks didn't always have the right to vote. Earlier amendments did not give the right to vote the way we believed that it would be by implementation. It took passage of the Civil Rights Act and the Voting Rights Act of '65 to actually get us where we needed to be, right? So when you look now at what the needs of the LGBTQIA plus community are, when you look at the intent and the desire of society as a whole right now, the Biden administration was sensitive to this need, right? And in being sensitive to this need, wanted to do its part to drive the conversation about the inclusion of issues such as gender dysphoria, which would then open the door to issues of transvestism and transsexualism and gender identity disorders being included as disabilities based on what they believe to be a societal need. So did they have a good idea? Yes. Was this the wrong way to go about it, given the fact that it's antithetical to the existing law and that can easily be proven in court? I would venture to tell you yes. But thinking that I could understand the logic or the rationale based on the leadership in Congress, they couldn't see getting it through both the House and the Senate. So if you couldn't see getting the law through the House and the Senate, what do? You look at the tools in your toolkit and you do the best that you can with what you have. And this rule was the best that they had. It's the best tool in the kit with what they had to work with. So now what you're looking at is, what is the American public saying about the direction it wants to go, and what is the perceived mandate? Well, the Democrats didn't win the presidential election. By way of executive function, the Democratic Party doesn't control the House and the Senate. Is that a mandate then, that whatever is espoused by the sitting Republican Party, based on what the campaign went on to support, is telling you that this isn't wrong and this is not the direction the country should be going now? So if the courts are staying decisions, you're saying, let me hold this in abeyance, let me sit to the side, let me not pay attention and progress this right now, to give the new party in power, the new president and his administration, an opportunity to revisit this rule and see, is there a rule that should supersede this, or should this rule be actually restructured? That's where we are right now.
All right. So for her next question, why have a final rule? Why have, quote, the final rule is unconstitutional, quote, and, quote, Section 504 is unconstitutional? Does that conflict with the AG's office? Does that conflict with the AG's office is saying?
No. This is the thing. If the rule that is written that way, courts are able to act, let me use some different language, sua sponte. So if I put issues before the court, you can also look at this as in the alternative. This is what you ask for. If I'm revisiting 504 altogether, if this rule is implemented, Section 504 is unconstitutional, because pursuant to 42 U.S. Code, Section 12211B1, transvestism, transsexualism, and gender identity disorders resulting from physical impairments are not protected under the Americans with Disabilities Act, and by association, therefore, gender dysphoria is not protected by the American or it's not covered by the Americans with Disabilities Act. So if this rule is read in as a disability and must be treated as a disability, that would make Section 504 of the Americans with Disabilities Act unconstitutional. That's why it's written that way. I don't think anyone's trying to get rid of. So the AG's read on this, we're not trying to abolish 504. What they're telling you is, if this rule is implemented and gender dysphoria is defined as a result as a disability, 504 is unconstitutional with that in there. That's why it's written that way. It wants to make sure broadly that the courts have the ability, because the court's job is not to make the law. The court's job is to interpret the law. So now the courts have to look at what the legislative intent is behind the Americans with Disabilities Act, and whether the legislative intent and the definition of disability consistent with the legislative intent was designed to include gender dysphoria. So this puts that issue for interpretation squarely in front of the court to correct matters forward, so states would not be in fear of jeopardy if they did not look at gender dysphoria as a part of the disability, being defined as a disability. And that's what caused the lawsuit to come about when it did. If the inclusion of gender dysphoria as a disability goes away, so too does this lawsuit. That's what the issue is. So they're saying, if we don't adhere to something that we know is fundamentally inviolate of the Americans with Disabilities Act as intended by Congress, you're going to stop or cut off funding for other areas that are covered under the Americans with Disabilities Act. It's going to affect my state funding. So what are these state AGs doing? Exactly what they should be doing. They're fighting to ensure that their funding or state funding is not affected that would be helpful in other areas. This is 504. You're talking about Medicare, you're talking about Medicaid, you're talking about accommodations in employment, you're talking about the Department of Transportation, you're talking about things under the jurisdiction of the Department of Health and Human Services. And these AGs are saying this could potentially, if this rule is implemented and we decide that we are not going to enact this provision, this puts our funding in other areas in jeopardy, and we're not standing for that. So this lawsuit is a protective measure. These folks truly are not trying to upset or upend 504 as it has historically existed for 52 years, especially in looking at public education and accommodations in public education now.
Okay. Let me change up my shot again.
Okay.
Just to give us some variety.
Are we good?
Yes, we are. Yes, we are.
Okay. And I hope this is helping.
It is. I believe it is. I believe it is. I'm gonna raise my lights up. Not too much on the glare. I'm gonna keep it right there, and I'm gonna come on this side. So before I get to Grace's next question,
Sure.
I am going to ask, and it may be kind of,
No worries.
maybe a little connection here. So she wants to know, should parents be worried if their kids are on a 504 plan? But I mean,
Absolutely no. Parents should not be worried about whether this would affect their children if they are on a 504 plan. Let's talk about what is colloquially referred to as a 504 plan in education. Let me give you the more definitive definition or wording for this. And this is from a former middle school and high school science teacher. In 504, what we colloquially refer to as a 504 plan, is essentially an individual education plan for specific or individual students. It's a student by student plan that is written and based on individual student needs, and it's structured and tailored to fit individual student needs based on students who have learning disabilities that are medically classified. So if you have a classification for being attention deficit or having attention deficit hyperactive disorder, and there's a belief that you need to do your testing under more stringent conditions, and you need quiet time or a quiet place, or you need extended time as a result of a learning disability, or you are dyslexic and that's a medical classification that you have that classification. What do we need to do here in our school to accommodate you without necessarily or per se upsetting the integrity of the education that you actually receive? And there is in some instances, there's stigma associated with it that there really shouldn't be. There are a lot of gifted and talented students. Their attention deficit with hyperactive disorder, and those labels create some issues. But the thing is, the accommodations to ensure that students can be successful without compromising the integrity of their education is what individual education plans, also commonly referred to as 504 plans, would be all about. People are more concerned about the abolition of the U.S. Department of Education, because the role that it has historically played and continues to play in providing guidelines structured in concert, working with states to ensure that there's some uniformity in how we're getting these things in place in the guidelines and rules for the creation of these 504s. So parents, in my humble opinion, should not be concerned. I don't think anyone is wanting to upset individual education planning for students with special needs and defined abilities consistent with what is written in the Americans with Disabilities Act. That's not what this lawsuit is geared at doing. That's not it at all. Apples and oranges.
So what you're saying is, this right here, this particular act,
Yes.
is something completely different.
What this is geared at, plain and simple, and we have to look at issues and what we're concerned about. Recall the Americans with Disabilities Act, and the purpose behind it is to prevent discrimination for folks with special needs, right? In public accommodations, in transportation, in education, in healthcare. It's broad sweeping to cover a lot of things that fall under the guise or leadership or guidance of a number of different agencies across the federal and in state government, right? So if that's what it does, this law, or not this law, but this lawsuit is geared toward one particular issue. We're not going to allow you to redefine disability pursuant to the Americans with Disabilities Act and its broad sweeping nature to include gender dysphoria. That is the single issue that this lawsuit is geared at guarding against.
Gotcha. So ultimately, this lawsuit really impacts who?
Candidly, the potential, it depends. When you say it impacts who, the answer is actually, it depends. If a rule were to go into play that defines gender dysphoria as a disability, it affects everyone broadly. It's broad sweeping, because when you're talking about this, it becomes a matter of the unconstitutional nature then of Section 504 because of its inclusion. It really would then affect states that are not willing to accept that gender dysphoria is actually covered by the Americans with Disabilities Act. That's who it would impact. Then it would, if it otherwise, on the other side of this coin, affects the LGBTQIA plus community and folks who would like to see the expansion of the definition of disability to include gender dysphoria to provide broader protections for the LGBTQIA plus community. So you've got the LGBTQIA plus community on one hand, and you've got state funding, and states, particularly conservative states, that will not integrate gender dysphoria as part of the American, disability pursuant to the Americans with Disabilities Act, at risk for losing funding in public education, transportation, and other public accommodations. Because if they don't include it and gender dysphoria is read in as a disability, it takes state funding away from the residents of those states, and it impacts the states, it impacts the health, it impacts issues affecting citizens in states with Republican-controlled legislatures and governors.
All right. And she has on here, what does stayed mean? How long does that last?
Stayed can be indefinitely. And what we talk about when this decision is stayed, it's stayed pending the outcome of something else. What the court wants to do before ruling on this case is the court actually wants to see what is going to happen under the new administration, and will this rule go away? If this rule goes away, the lawsuit goes away. If the rule is implemented, the lawsuit must continue, because you have to have a case in controversy that is ripe for consideration under the United States Constitution and order constitutional law. There has to be a real case in controversy. If this rule is not implemented and gender dysphoria is not defined as a disability, there is no case for controversy. If the rule is implemented and gender dysphoria is included as a disability, the case is ripe for consideration. So it stayed until the Trump administration and Secretary of DHHS makes a determination of what to do with gender dysphoria and whether or not it will be included under this rule, as a disability. So once that determination is made, the courts will know how to proceed. either to dismiss this as moot or to move forward and consider it.
All right. And earlier, once again, when we were talking, I remember I asked you from as we were talking, I was trying to get an understanding of this, and knowing that this is, correct me if I'm wrong, knowing that this is not connected to a thing of special education in the schools, right?
No.
I asked you, I said, hey, is this like a war on gender? And you told me that this is mainly a thing of tradition.
I think that what we're looking at right now, when we look at 504 and we look at what's going on right now, what you're looking at from the change of one administration to another, what are the priorities of the country? And right now, what we can tell is we've transitioned from a moderate to progressive Democratic president to a seemingly conservative Republican president who wants to look at tradition more so than expansion. So you looked at the Biden administration and the things that it sought to put in place as providing broader protections that took into consideration more people. So it was expansive in nature. We want to bring everyone in under the umbrella, the big tent. We want to make sure that everyone is included. That means people with issues and concerns and considerations regarding sexual orientation and anything that's tangentially related. That was the Biden administration take. The Trump administration, look at executive orders that are coming out, the fact that we don't want to provide care for transgender folks under the age of 19 in states right now, putting in place an executive order that says this. We want to pay attention to how you were biologically born. And what that essentially does is turns an entire movement that affects a broad swath of people across the American population on its head. So what we're looking at is a return to what is traditional and setting aside and being unattentive to or not as attentive to people who are not consistent with what we see as traditional values and norms. Traditional values and norms mean a heterosexual family structure. Heterosexual norms mean if you were born a woman, you are a woman and you cannot identify as a man. We are not going to respect that. Or vice versa, if you're born a man and you decide that you want to identify as a woman, we're not going to permit that. Whatever your biological parts are that you were naturally born with, that's what you are. So that is the spirit, it seems, of the current administration and thematically what they want a return to, but it doesn't account for what's normative for a broad portion of the population that seems to be growing right now, and making sure, as we look at laws and things do evolve over time, and the laws are supposed to meet the needs of society and not cast them aside. So this is a much broader discussion, and that's really what is at stake here, more so than having a conversation about whether my child can have their 504 or individual education plan in our schools.